Most of you won't ever think that you'll be accused of being drunk in charge of your vehicle, but this video might surprise you. So following my previous video, there were lots of questions and comments about sleeping in your vehicle, sleeping in a motorhome, whether you're sleeping in the street, on a caravan park, in a pub car park, and so on and so forth. And questions about what it actually means to be in charge of the vehicle. Somebody even said if the keys are not in the vehicle, it's not possible to be in charge of the vehicle. But that's strictly not true. So welcome back, but if you're new to me, I'm a barrister who helps you understand law. So in this video, a few warnings about being drunk in charge, because it's quite a severe penalty. So let's take the scenario where you only have street parking at your house, or even if you have a driveway, the driveway is full or otherwise you can't access it and you're parked in the street. If you are inside that house and your car is outside, and you are above the specified limit for alcohol or specified drugs in your system, then you may well be in charge of that vehicle. Now, of course, there is a statutory defence to this, which is if you can show on the balance of probabilities that there was no likelihood of you driving the vehicle, but we'll come back to that in just a moment. First, dealing with the raw fact and definition and assessment of being in charge of that vehicle. Now, whilst there is no specific definition of being in charge, courts are to use judgment when determining whether in fact and as a finding of fact whether you were in charge of that vehicle on a public road or other public place at the requisite time. Now, even if you don't have the keys and even if the keys are not in the ignition, take the scenario where you come out of a pub and you've had far too much to drink, your car is outside, you've decided not to drive it, but you still want to get home and you still want to take the car home. What if somehow, let's say you've left the vehicle open and you then take the handbrake off and you start pushing your car down the road trying to get the car home? Clearly that's not right. You are without doubt in control of both the direction and the speed of that vehicle, albeit you probably won't be pushing it very quickly. But then what if you get to the brow of a hill and you lose control of that vehicle? Then without doubt you were in charge of that vehicle because you got it to the brow of a hill and then you lost control. So for that reason, it doesn't matter whether you had or have the keys, or the keys are in the ignition, or even if the engine is on. If you are found in the middle of the road pushing a vehicle, particularly if you're near a hill or near other vehicles or pedestrians and so on, then make no mistake, you are in charge of that vehicle. And if you are over the specified limits for drugs or alcohol, then you may well be charged with this offence. Now, I said I would come back to the defence, which is a statutory defence. Now, this is a bit of a strange one because you are the one that has to prove it. The prosecution does not have to disprove, rather you have to prove on the balance of probabilities, because as a defendant you do not have to prove beyond a reasonable doubt that there was no likelihood that you would drive the vehicle, just on the balance of probabilities that there was no real likelihood that you would drive that vehicle. For example, if the police stormed into your house, found you asleep upstairs, your vehicle outside, tested you, and lo and behold you were over the specified limit and then charged you, you would probably have little difficulty in discharging your burden in that you had no real likelihood of driving the vehicle because you were in bed asleep. Now, this is probably not the most common scenario you will come across, but technically the argument could have been made that you were in charge of that vehicle, albeit you have a very obvious defence. But replace that with a scenario where you are at home and the vehicle is out on the street, and you and your partner or friends are having drinks and everything is fine. You have genuinely no plans to leave the house. You are there for the evening and nothing more. However, if a big argument breaks out and one of them tells you to get out of the house, you're no longer welcome, whether you're a guest or otherwise, and you're told to get out of the house, and then you decide, well, you can't drive anywhere, but you decide to sleep it off in your vehicle. Then you get out of the house, you go into the vehicle, you might well decide to sleep it off, but you are unquestionably in charge of that vehicle, and this is where it is a strict liability offence in that you are over the specified limit and you are in charge of the vehicle. you would then have to prove that there was no real likelihood of you driving the vehicle. However, that might not wash, because if you are in the vehicle and you are in charge of it, there is at least some likelihood that you might drive that vehicle whilst over the specified limit. So whether this is a normal vehicle, whether it's a motor caravan, if you are on a road or other public place and you are over the specified limit, you really should be prepared to justify that you had no real likelihood of driving if you are in the vehicle, near the vehicle, or even in a building adjacent to the vehicle whilst you are over the specified limits. Another example taken from a real case was when two people were working late at an office and having drinks. They had no intention to drive the vehicle that was left outside on a public car park, which is a public place for the purposes of the legislation. One of them had realised that he'd left some files in the vehicle and asked his friend to go fetch them. Handed him the keys, thought nothing of it, went down to the car park, leaned inside the vehicle to retrieve the papers, and then out of nowhere, two police officers turned up and arrested him for being drunk in charge of the vehicle. Now, it's at this point that I always make the very sensible suggestion that instead of being combative and argumentative with the police officers, if you simply explain what has happened, that you are only coming to fetch files and you are tidying up the office, and after which you're going to walk home or sleep in the office or whatever it is you're going to do, that is much more likely to be beneficial to you than if you get into an argument with the police officers and then they are less likely to believe that there was no likelihood of you driving the vehicle. Another warning to bear in mind is the post-incident drink scenario, where you may have genuinely been involved in some kind of road traffic collision, where you might have gone home and had a drink to try to calm your nerves from the incident. If the police were to follow you and then breathalyze you and find that you are over the specified limit, it will be assumed that your blood alcohol levels were at least the same level at the time of the incident, unless you can show otherwise. And this is what we call a reverse burden of proof, in that it is on you to prove on the balance of probabilities that this was not the case. Both of these statutory defences can be extremely difficult to present, and I would not suggest that you try to present them yourself, not least of which because you are always going to be a little bit nervous when representing yourself, and it is always recommended that you have somebody do it for you. So once again, and as I say in many of my videos, it always comes down to the evidence, but beware also of self-serving statements. So if you do make plans that you're going to stay somewhere else or get a lift home, then do make those plans ahead of time, but don't make it look like it is just a self-serving statement, sending messages to a friend that you're not going to be driving your car later, because it will look like a self-serving statement. And remember that previous consistent statements are not always admissible, as against previous inconsistent statements that show that you may have changed your story. Whereas if you do have a plan and you have a pre-booked taxi to bring you home, make that in advance so that it's quite clear. You can show on the balance of probabilities you had the taxi booked, maybe even pay for it or make a deposit on it, so that there's no real likelihood that you're going to be driving the vehicle because your ride home has already been booked. I hope this has served to clarify some of the questions. Please do like the video and subscribe, and as always, thank you so much for watching.